throw you the ball. You should see a bubble come up. As soon as you accept that, did I lose you? Did you have a bubble come up there? Oh, there we go. Great. Okay, Elliot.
Okay, well, thank you, Jason, for introducing me, and welcome. I hope this will be informing about non-conforming uses. This is one of the traditional areas of land use law it's kind of a source of much consternation in my experience, that working with cities and working with land use. Non-conforming uses are a kind of a unique area of the law. I want to start off with the story. This is my personal experience. When I was growing up, we had cattle, a corral behind our house, my parents' house. My family has a cattle ranch, and as long as I could remember growing up, we had corrals behind our house, and we would had our animals there. And it was a non-conforming use. The city zoning had changed many years ago, but we were allowed to keep the corrals and keep the animals there as a non-conforming use. They're no longer there now, but when I was growing up, we had these animals there. And when my sister was in high school, she invited her friends over, and was horrified when she looked out the window and saw that the bulls had gotten out and were grazing in the front yard. And my mom wasn't real thrilled either, especially when one of them started rubbing on the shrubs and pretty much destroyed it. Anyway, my brother and I thought it was a hoot, though. But that's my experience with nonconformity. And in fact, keeping animals is a fairly traditional non-conforming use, that people have kept animals, on their property for many years. And as cities have grown and, new residential neighborhoods have sprung up, sometimes they come in conflict with, animals being kept in a field that for many years nobody was concerned about it, but all of a sudden it becomes a concern because of new homes coming in. So let's start off with what we mean when we say non-conforming use and a non-complying structure. This is from the Utah Code. The definition: non-conforming use legally existed before the current land use designation and has been maintained continuously since the land use ordinance was changed. But because of ordinance changes, it no longer conforms. In other words, it is no longer legal. It no longer conforms with the zoning ordinance. And a non-complying structure is the same thing. It was, at the time it was built, it complied with the land use laws, but because of changes that have happened since, it no longer complies. And the way the ordinance is written, it talks about conforming to the type of restrictions that would be placed on a structure under the zoning ordinance, the setback, height restrictions, area restrictions, things like that. So those are the definitions from the Utah Code. And a non-conforming use or non-complying structure may continue by the property owner, and it may be continued by multiple property owners. So in other words, a non-conforming use status runs with the land. A non-conforming use is a type of vested right. I say a type of vested right. The vested rights, for the people who are familiar with it, there's a vested rights rule which applies to development. Non-conforming uses falls under that general umbrella of the vested right, a vested property right. It's a right that arises because of reliance on past zoning ordinances, and it's a right that arises because of use. not because of any timing or application, but because there has been a use that was undertaken relying on the past zoning ordinances. The conflict is that you have a use that shouldn't be there. That's the whole point of non-conforming. And so part of the policy for a non-conforming use is that we should encourage compliance through appropriate means, which basically means phasing the non-conforming use out, either discontinuing it or phasing it out. As I mentioned before, a non-conforming use or a structure may be continued. In other words, if you have a use that even if it's would not be allowed today, it can be continued if it was established yesterday. But that does not mean that a non-conforming use is exempt from regulation. A local government may adopt terms and conditions governing non-conforming uses, and they would continue to be subject to general laws, for example, concerning nuisances. And a lot of people, there's a misperception that non-conforming use means that they're somehow exempt from the law. They're not. They're allowed to continue, but they are still subject to general laws the way that any use would be. When we say that a use has legally existed, what that means is when the use was first established, it must have been allowed under the former zoning ordinances, either as a permitted use or as a conditional use, or somehow under the former zoning ordinances, that this use is something that could have been done and was established at the time that it could have been. And it's not enough to say that this is something that could have been done under the former law if it was a year ago or 10 years ago. You have to show that it was actually done. And then along with that, any approvals that were required in order to become established must have been granted. For example, if the use was a conditional use, then in order to be legally established or legally existing, then you need to have a conditional use permit to establish that use. There's been some discussion, in fact, as I understand, a few cities have included in their ordinances that if a structure didn't have a building permit, then the logic is that it doesn't legally exist because, and I'm referring to the use, not the structure, but the use isn't legally established if there wasn't a building permit for the structure in which the use is carried out. And specifically, that's referring to apartments, basement apartments and the like that may have been allowed. And a lot of times people would open up a basement apartment and do so without getting the building permits that were required. And this specific question actually went to, it was the Utah Court of Appeals. That's been 6 years ago, I think it's 2009. It was out of Provo, where there was a basement apartment, and the city, and it was in the city ordinances, and the city argued that this basement had been converted into a separate apartment or separate living quarters without getting the building permits that would have been required at the time, because of the structural changes, the electrical changes, and the sort. The Court of Appeals, the Court of Appeals rejected that and said, okay, they didn't get a building permit, and that refers to the structure, but you don't need a building permit to establish a use. So that's, again, that's one of the kind of the strikes against a non-conforming use, I guess, that a lot of times these uses just exist. There was never really a formal process to create them. They're just kind of there. Very often, the whole issue of nonconformity comes up because the use becomes a problem. People start to complain. And so that's kind of one of the drawbacks of nonconforming, is that you're asked to go back and look at what's happened in the past, and there just aren't good records of what happened in the past. So the approvals, any of the approvals are required. That would include a conditional use permit. A building permit would be evidence that a use had been established, but it doesn't affect whether the use was legally established. Being maintained continuously. The use has to be established. This is not something that, in other words, you have to actually be carrying out the use. You can't say, well, we meant to or we wanted to under the former laws. What the approach is, or should be, is that the use can exist in essentially the same form as it had when it first began, and should not have been expanded beyond what was allowed under the former ordinances. Again, this goes back to kind of the policy or the philosophy behind a non-conforming use. It's not carte blanche to do whatever you want. It's a special legal status that allows use to continue under the correct circumstances. The use can't be changed to a different use, and this is actually more complicated than it looks. It sounds a little obvious. For example, if we had, I mentioned before, we had animals, corrals, and we kept cattle behind our house when I was growing up, and that was a non-conforming use. Could we have changed that, say, instead of cattle, could we have changed it to horses? Well, probably, because the use wasn't really specific to cattle, it was animals. So other than the number, I don't think the number of animals would have been, there would have been any difference in animals. However, we couldn't have turned that, just because we had a corral of animals, we couldn't have turned it into a slaughterhouse and, killed animals, turned into a butcher shop, for example, because that would be a very different use. There was it's a case that was actually out of Springville where there was a company, and they had, the first owners, what they did is they made tanks, fiberglass tanks, water tanks, and septic tanks, and these types of structures. And that business didn't do so well, and they closed down, and new owners purchased the building shortly thereafter, and they decided to, instead of making tanks, they converted the building into an ice factory, an ice plant where they would produce ice and ship it out. It was a non-conforming use. This is the zoning. When the tank manufacturing began, it was allowed under the zoning, but the zoning then changed and was much more restrictive. And the city fought that, and it went to, this is the Supreme Court, Utah Supreme Court. And what the Supreme Court said was that manufacturing ice was a significantly different use than the tank manufacturing that had been originally established. And I think what was critical was the use was defined in the city's ordinances in a more restrictive manner. Because if it had just been, say, manufacturing or some general industrial or something, some very generic term, well, that would imply that pretty much anything that would be considered manufacturing could be continued. But if it was defined specifically, and more restrictive, then it would be more appropriate to limit the use. And again, I want to emphasize, non-conforming status is granted because of past use, not because of a proposed future use. So again, the use is no longer allowed, the non-conforming use. In our case with our animals, the city changed the zoning and restricted keeping animals within the zone where my parents' house was actually right in the middle of town, so it was appropriate to say, you know, hey, we can't have animals there anymore. And actually, we still continue it, but to a much lesser degree. We actually have a couple of horses, and they graze. This is again behind my parents' house. They'll graze in the field for a limited period of time, but it's only 2 horses. It's not several animals that we had before. The conformity or no longer conforms. So the zoning ordinance changes, and so the use that was allowed is no longer allowed. That can also include the intensity of the use. For example, the number of animals. And there's been some cases actually recently where the number of animals that could be kept on a property has changed. And even though I mentioned the situation where we have 2 horses that we graze behind my parents' house for actually just a few months of the year, that's the intensity of the use. It's gone down from, say, a dozen or maybe 20 or so head of cattle down to 2 horses that are in the field. So the conformity can include the intensity of the use. That maybe allows, say, 5 head of cattle that can be changed to 3 head of cattle. And then there's a discretion, and again, this is kind of where we get into the fuzzy area of non-conforming law, is that local governments would have the discretion to substitute similar uses. This is what I mentioned earlier with the ice factory versus manufacturing tanks. The city could, and first of all, the city could have allowed it, number one, but secondly, this also goes to the language of the city ordinances. If the city just said, well, manufacturing was allowed when the tank factory was first built, well, that could be really pretty much any kind of manufacturing. But if the ordinances were more specific, then you would limit the possible uses under the nonconformity to what was allowed under the former ordinance. So the secret there that is critical to the city's ordinances, the city's zoning code, be specific, as specific as not as specific as possible, but as specific as is reasonable. Okay, let's turn to non-conforming structures or non-complying structures. There's a story behind that, but we won't go into it. Structure does not necessarily mean a building. It could be, for example, it could be corrals for animals, fences, that sort of thing. The structure, when it was first built, it would have complied with zoning ordinances, but because of changes, it no longer does. This is where a building permit is evidence that the structure legally existed, because a building permit is necessary to build a structure. And would also apply to modifications to older structures. And just to mention and just to emphasize, billboards are structures, yes, but they are subject to separate ordinances, and we won't discuss that here today because it's a completely separate statutory scheme that covers structures. Also want to mention non-complying lots. Non-complying lots are not found in the Utah Code. Several cities and counties have adopted statutes that apply to lots that no longer comply. And recently, a few years ago, the Utah Court of Appeals applied, what they did is they basically applied the non-conforming analysis to non-complying lots. A non-complying lot is basically it's a lot that is now substandard. A lot that it's, and like I said, they apply the same analysis. So it was a lot that was legally created. It was legal when it was created, but has now become non-complying. It no longer complies with the size or the dimensions possibly because of zoning change, but also what happens sometimes that a lot is perfectly legal, but because of say a road widening or some other public project that takes property from it, the lot suddenly becomes too small, say, and becomes a non-complying lot. So the analysis is that if the lot were legally created, but is now no longer complies with, again, with the zoning ordinances, it can still be used as a building lot because it was basically, the lot became non-complying through no fault of its own, I guess is the way to say it. Here we go. We go backwards. There we go. I got it. Sorry, I jumped ahead a little bit. The non-complying lots, we're back on non-complying lots, can still be used as a building lot as long as the overall dimensions are allow it. For example, our office not too long, well, it's been a while ago now. We dealt with this is actually a lot in Salt Lake City. It's in the center of the city where the lots in Salt Lake were very small. There's some very small lots in the central city in the avenues area in particular, and in some areas these lots no longer suit or fit the size requirements that Salt Lake City has, and the city actually has an ordinance to cover this, and it says what it said was that it could still be used as a building lot as long as there was substantial compliance, I think was the overall theme, as long as the lot was still large enough to accommodate a building. This is another case we dealt with. This is in central Utah, where this lot started out as a very large range. It started out as a homestead, in fact, but over the years, parcels had been carved out and divvied out and distributed out and so on. So all that was left of the original lot was actually a very tiny corner that had been left over. It was actually inadvertently left over as they started doling out the different properties. They kind of forgot about this, and it was way too small for any practical building. It was just a triangular shaped piece that just kind of got left over. Even though it's technically a non-complying lot, but from a practical standpoint, it just couldn't be used for very much, and certainly not for any kind of practical building because it was just too small. And in that case, really the only practical approach in that case is just take that property and merge it into one of the other lots, so that at least it can be used, and you kind of clear up that problem. I also want to emphasize, and this was the Court of Appeals referred to these non-complying lots, and what they emphasized was that the lot was created and physically created at a time when it was legal to do so under the subdivision ordinances of the time. But what that does not mean is that that same property continues under the old ordinance. And again, this goes back to the whole philosophy of with a non-conforming use or structure, or in this case a lot, it doesn't mean that it's exempt from regulation. And it doesn't mean that the former statutes are frozen forever for that property. But the court said, look, if you've created the lot under the old law, then that lot can continue to exist. And actually the issue in the case that the court was considering, the owners claimed the right to continue to subdivide under the former law because they had started to subdivide under that law. And the court said, no, they'll recognize the lots that were created, but going from the past, but moving forward, you have to comply with the new law. And this is actually a similar situation we rose up. This is we were discussing with the county, and what they were creating or considering creating a scheme where if property, the uses that would have been allowed on a property would be tied to the ordinances that were in place when the lot was first created. So in other words, if you had a property, and let's say the subdivision and the lot was created, say 1990, then you could carry out whatever uses were allowed in 1990, whether or not you had ever tried to do that. But if your lot was established in 1995, you would be limited to the uses that were in the 1995 ordinance. They came to our office to ask us, well, can we do this? And our first answer is, well, yes, you could probably do that, but do you want to do that? Number one, it would just be a nightmare to administer because you'd have to track every single lot, what year it was created, what uses would have been allowed. And you also run into not just a practical, but actually kind of a political issue because what if you had the guy that his lot was created in 1990, well, he can carry out whatever list of uses. Well, someone across the street, their lot was created in 1995, so they don't get to do what the 1990 lot gets to do. So you've got a political issue of how come the guy across the street can do this and I can't. So not a very practical solution. I understand I guess the motivation behind it was that people were owning property and were hoping or intending to do particular uses, but not a very practical solution to that. Okay, so how do we confirm non-conforming lot status or lot or use or structure? Again, what happens very often is non-conforming doesn't become an issue until it becomes a problem, until people start to complain. And that's part of the problem is where we have a use that may have existed and nobody cared about it for many years, decades even, and it only becomes an issue when someone complains. So it would be very rare that a person comes in and says, I want to confirm that I have non-conforming use status. What happens more often is someone complains and the ordinance enforcement comes out and says, well, you need to stop doing this. And he says, well, wait a minute, I'm entitled to grandfathering. That's what they call it. I'm grandfathered in, which is grandfather is a nickname for non-conforming status. So then we have to look at the evidence. Was this use, first of all, was it legally established under the former ordinance? And has it been maintained continuously? The staff, again, this is the normal process. The staff would look at it and say, well, no, this is not a non-conforming status. That determination can then be considered. It's usually considered by an appeal authority, which is the Board of Adjustment or a hearing officer. I put on the screen that says it's proven by a preponderance of evidence. That's from older cases. The more recent cases have said that it's substantial evidence. And they've actually drawn that from LUDMA, the Land Use Development Act. In the appeal section of LUDMA, it talks about that an appeal authority's decision will be upheld if it's supported by substantial evidence. So the more recent cases dealing with non-conforming uses have adopted a substantial evidence standard. Older cases say a preponderance, and preponderance is a little more difficult. When it comes to the point that it's necessary to confirm the status, this is where it'd be the opportunity to come in and say, all right, this is what can and can't be done. So you state the type of use, the extent, or what's sometimes referred to as the intensity. But I gave the example earlier, the number of animals. we may have had 20 or so head of cattle in our corrals years ago when I was young, and now we're down to 2 horses. And again, because non-conforming status is based on historic use, the use may be limited to the historic level. I've seen this situation where a use is actually may have been a business or a use, which at one time started out pretty strong, but then kind of petered down to very little or really a nominal use. Even a ceremonial use, just to say that we've maintained it, and then the new owner comes in and wants to fire it back up to full production. Well, the use can be limited to what the historic level is, and again, I would suggest that this be included in a local ordinance. That the language to the extent that the use can be the level of the use can be determined by the historic what the historic use has been. I refer to that as shrinking the use. For example, in our situation with the animals, we may have had 20 or 25 head at one point, but that nonconformity, that use, has shrunk to 2 horses. We can't go back to the 25 head, or a new owner can't come back and say, "Well, you have animal rights. I'm bringing my herd of longhorns in. We're driving them up from Texas." Would not be able to do that because the use, the historic use, has shrunk down to 2 animals. The same concept would apply to manufacturing, other types of uses that would be non-conforming. Can a local government impose conditions on the uses? State law is pretty much silent. It doesn't say whether conditions can be imposed. It does. There's language that the local government has discretion on the expansion, continuation of the use, but it doesn't really say that you can put conditions. It is my position that yes, they can, particularly if it's put in a local ordinance. They could put conditions on uses in the same way that you could on a conditional use or a variance, for example. Conditions could include landscaping. It could include hours of operation. Even things like, for example, paving, or I say paving for parking, fencing, that sort of thing, to mitigate the non-conforming uses, and also to bring them in compliance with standards that would apply to other uses. Just because some guy's out in the middle of some overlooked corner of the town and is carrying out whatever offensive use that you can think of, they're still subject to general laws, and so among the conditions that could be put in would be the same types of conditions that would be imposed if the use were new and allowed. And again, preferably included in a land use ordinance. And the conditions should be reasonable. Okay, so how do we get rid of these blasted things? There's only 2 ways to terminate a non-conforming use, and by terminate I mean completely close it down. It is either through abandonment of the use or through amortization. Let me go back. Abandonment, use is considered abandoned if it is not used for at least 1 year. And by abandonment meaning that there is no activity. If it's a retail or a manufacturing business, there's no business going on. So it means fully abandoned and not used for 1 year. Amortization is very controversial. A few weeks ago, I was at a conference, and there was a presentation specifically on amortization, and one of the audience members, he was an attorney, he raised his hand. He says, the only way amortization is successful is if you don't do it. But Nevertheless, there it is. It's in the state code. What the state code says is that a city or a county may adopt or create a time frame where to allow a person to recover either the investment or the cost of the non-conforming use. It's a very complicated issue. It's not a matter of just saying, "Well, we'll give you a couple of years." You know, you have to. The approach has been that you determine the amount, either the amount of the investment or the value of the non-conforming use, and then from there you consider if there's an income stream from the use, which isn't always the case. Either the income stream or if there is no income stream, then what you'd use is a normal depreciation formula. And that's maybe the key to the amortization, is that you're kind of borrowing the concepts that are found in estate planning and tax issues of you have an asset, the use is an asset, and it has a value, and the property owner is given a reasonable amount of time to either recover the value of the asset if it's income producing, or to depreciate the value over time. There have been some cities have attempted amortization, and it has been successful. There was a case, this came out of Provo, where Provo adopted an amortization. This is for, again, it's for rental apartments. Provo's declared war on apartments, these non-complying apartments, for, several years ago. And they, in this particular case, they went through the process and they determined, okay, this is what the value of this property is. And this family had purchased this property and modified it into two separate apartments. I think it was either two, or maybe it might have been a duplex. And what the family was doing, they were renting it to close relatives at below market. And so the family's argument was, okay, this is the value, but our income stream is actually less than is what would recover the value. So what they argued that there's an infinite amortization period because they were renting it below value. And Provo countered that, says, all right, we'll use a reasonable rental value, in other words, kind of a market value, which the court the court accepted that. They said, yeah, you can't have an infinite amortization period; it defeats the whole purpose. And the court said, yeah, you can use a reasonable rental value and use that as the basis for the amortization. And in that case, I believe the amortization period was still 22 years, even with a reasonable rental. So the two secrets to amortization is, number one, you've got to crunch the numbers. You can't just pull stuff out of the air. And number two, you have to be patient. If it takes 20 years, then it takes 20 years. And the cities need to put their foot down and say, we want to amortize this out. Amortization is kind of the frontier of non-conforming uses. Even though it's there, it's in the state code. It isn't used that often. As a matter of fact, Provo has basically abandoned any approach of amortization. They repealed the ordinance that has it. I believe Ogden and a few other cities are still carrying this out. This is an example. This is actually a city ordinance. Talks about junkyards. Nobody likes junkyards except the people and the dogs that live there. Notice what it says in this language is, notwithstanding any other provision, automobile wrecking yard shall be discontinued within 3 years. There's a problem with that. That's an automatic amortization. It applies to everybody. The state law requires an individualized analysis. And so you can't just say junkyards get 3 years. And a reasonable time period to recover the investment. That may be 3 years, it might be less, but you can't just have a blanket statement saying 3 years or 1 year. We actually got a call not too long ago where it was a city said, well, we think 1 year is reasonable without doing any kind of analysis. So the amortization, basically it takes a little more work, takes a little more legwork, some elbow grease, but it can be done. Okay, so how do we terminate a non-complying structure? Again, there's only 2 ways. It's voluntarily demolished, or it becomes unsafe or uninhabitable to the point that the city, excuse me, to the point the city wants it taken down. Our office not too long ago did this is on the voluntary demolition. It had to do with a pole sign, and this particular city doesn't like pole sign. They wanted to change it to a monument sign, the lower sign. The reason the pole sign was removed was because UDOT was widening the road and had acquired the property to widen the road, and so the pole sign had to be moved out of the right-of-way. Well, the city argued that was a voluntary demolition because the property owner had voluntarily agreed, that signed the agreement with UDOT. The UDOT purchased the property for the road widening, and that was voluntary, wasn't it? And what our office analyzed it, and we said, well, under that circumstances, that even though we kind of had to stretch the law a little bit, but we said that that was not a voluntary demolition. First of all, he didn't agree. The part of the agreement wasn't moving the pole sign. It was he agreed to sell the property. And if he had not, UDOT would have gone ahead with an eminent domain proceeding and acquired the same property and moved the pole sign anyway. So we held that he had not voluntarily demolished the pole sign, and it could be continued and relocated within the same general area. So, okay, we kind of stretched the law a little bit, but under those circumstances, it was the fair thing to do. If the structure, when we say voluntary demolition, it doesn't mean an accident or, for example, a fire. If a building is destroyed because of a fire, that's not voluntary. So the owner would be, what they do is they would be allowed to rebuild the structure in the same location. However, if a new structure would have to comply with, for example, current building codes, electrical codes and that, they could build it in the same location. They could be in the same setbacks, even the same height. Again, the nonconformity is nonconformity with zoning ordinances, not building ordinances. A common situation that arises with structures is, again, where there's been a road widening. And I mentioned this earlier with the lots. The lot could become nonconforming, but another situation which arises it's very common is that the structure becomes non-complying because it is in violation of a setback, not because of any action on the part of the owner. It's because either the state or a local government has acquired property to widen a road. In that situation, in fact, I know that several cities have adopted an ordinance that said that saying yes, these structures are allowed. The home or a building is allowed on the property. In other words, and why that's critical is because of financing. Banks will, if they're aware that there may be a problem, they may have a problem with financing. So several cities have adopted or say, okay, look, you can still build the building, you can build a new building on the lot. It's just because of a setback that because of the setback, the structure becomes non-complying. Again, that's not a voluntary problem, and the property owner should be allowed to continue the structure or rebuild it, although not necessarily in the exact same location. They can still build on the lot. moving on to becoming unsafe, one of the first cases, or one of the bellwether cases in Utah, is called the Rock Manor Trust, and it dealt with. It was originally a barn, apparently, and this is in Davis County. It was just south of Lagoon, and the structure had been there for forever and a day. I think Brigham Young may have stopped there on his way into the valley. I don't know. So this structure was there. It was owned by a family, and they advertised family businesses on it. And it was actually started with UDOT. The Rock Manor case was with UDOT because it was near. It's right next to I-15, where a fire had destroyed the barn, and the family said, "Well, we rebuilt it. It was an involuntary demolition." And UDOT said, "No, you're not allowed to." The Utah Supreme Court, this is in the 70s, said, "No, you can keep the structure. It has been burned down." They waxed poetic about a phoenix rising from the ashes and all this stuff. So this barn-like structure sat there for the next 40 years along I-15, and actually because of changes to I-15, you actually couldn't see it, or you can only see it briefly on the southbound lanes, which is strange. Well, let's fast forward to 2013 or 14, just the last couple of years. The city of Farmington investigated the same building, the same structure, and determined that it was unsafe, and they ordered that it be torn down. Well, the city fought it, and I actually spoke with the patriarch of the family. He's an attorney, and he fought that and went to the Court of Appeals, and the Court of Appeals said, well, the city has determined that it's unsafe. And so under the city's ordinances, the building could be torn down. The family then argues, well, we have a chance to replace it. That actually went back to the Court of Appeals. There are two cases on this, and the Court of Appeals upheld it and said, no, it comes down. And the infamous Rock Manor Trust barn is now gone. It was torn down. There's two cases over the last couple of years that dealt with that. I'm proud to say I had the opportunity to visit it and see it with my own eyes before it was torn down. So, non-complying lots. If the lot becomes compliant, then the status is terminated. There's no need for being a non-complying lot. And there is, and our office dealt with this question, if there are two non-conforming lots, but two adjoining non-conforming lots that become owned or are owned by the same person, a local ordinance may require that the lots be combined. And so you're probably looking at it saying, how often does that happen? Well, it happened at least once because the owners came to our office and asked if it was valid, and we could see no reason why it wasn't. We felt that it was an appropriate use of the city's authority. It was appropriate to reduce the nonconformity, and it encourages the economic and efficient use of land. What had happened was there was an original lot that was owned by a couple, and they split it in half and gave one half to their son, who built a home on it. And then when the parents passed away, the son inherited the first lot. So even though there were two lots that would have otherwise qualified as non-complying lots, non-conforming lots, he found himself the owner of the two lots that were adjoining. And the city ordinance that had been put in place required that they be combined. And so even though in unusual circumstances, we could see no reason why that wouldn't happen. Okay, so non-conforming uses are not exempt from regulation. General nuisance laws, for example, noise, odors coming from animals or from manufacturing concerns. Just because it's a non-conforming use doesn't mean it's excused from compliance with the regulations that would apply to everybody else. They still have to exist within the community, obviously, and so if there's a noise problem, then they're not excused from that. And non-conforming uses also may be subject to nuisance lawsuits, private suits from neighbors. And this happens, there's a legendary story, again from my hometown, where it was actually it was a neighborhood that was marketed, the homes were marketed as having animal rights. And so they have they're large lots, like an acre, and several of the homes took that literally and have animals. They have horses, horses, and I think even a couple have goats. Well, some of the other people moving in, they thought that animal rights was just kind of a cute selling point for the subdivision, but didn't actually mean animal rights. And so the neighbors were at odds with each other over their animals. They started complaining about, this filthy, smelly horses on the neighbor's lot. And the neighbor said, but when you purchased your home, you purchased it as a horse property. And so the neighbors actually argued back and forth to the point that their local ecclesiastical leader got up in church and basically bawled them out. And that it cooled it down, although I've actually spoken with a couple of people, and there's still some bitterness going back and forth about these problems. But it does kind of raise the issue of you're still subject to a nuisance suit, allowing, or if the use is allowed, that's a defense, but you're still would be subject to a nuisance suit. Okay, what about altering a use? We've mentioned earlier that the intensity or the level of the use can be shrunk or reduced down to historic levels. But what if I want to change from my tank manufacturing to ice because producing ice is more profitable? Well, the state law says it includes altering a non-conforming use as part of the authority of a local government. So local ordinances may allow that a use could be altered. But again, bear in mind that the overall policy should be to encourage compliance and not to allow more non-compliance. And that's what I meant on the slide where I put that should avoid enlarging the use beyond the historic levels, and in other words, making it more non-conforming. That would the only guidance I can give is either if have an ordinance language that would cover it, but it's within the discretion of a city or a county to make these decisions, and understanding that in many cases a non-conforming use is economically valuable, not only to a person's livelihood, their economic investment, but also to a community. So you need to weigh all those factors of whether the use could be altered. A new law is that I'll just mention this briefly, that it affects specifically rental dwellings, and this the legislature passed it just this last spring. It limits the physical changes that are required for rental properties, and specifically it regulates upgrades to egress windows, emergency exits. What has happened is we have several, in some communities, there are several buildings which are older buildings which are being converted into apartment units, and these apartments, in fact, a lot of them are basement. I had some friends. They were attending BYU, and their apartment was a joke. It was in the basement, and we had to duck in and out of the ductwork, because you had ductwork was down low, and I'm pretty tall, and so is my friend, and so we'd go in there, and we had to bob our heads up and down to dodge the ductwork, and the windows. Of course, this is an older building with those small those small basement windows like in your grandma's house, are not, they really aren't suitable as egress windows under the building code. What the legislature did was basically exempted those from changes. And I've got the citation that covers that. So that limits what a city can do to physical changes to an existing rental dwelling. Just to close up, any questions? Please give us a call. We've dealt with non-conforming uses, and we deal with them on a regular basis. It is part of specifically part of our jurisdiction. So feel free to give me or Brent or Jim a call. And we'll wrap it up here, and if there's any questions.
Yeah, folks, you can go ahead and type your questions into the chat box or the Q&A box. I've got a question. Do lots have to be recorded to fall into this non-conforming use?
The case that dealt with that came out of Kane County, and what had happened is that this owner had started. He had divided up property, owned hundreds and hundreds of acres, and had started carving out lots under the former ordinance. And so he went through the proper subdivision ordinance, which would include recording. And since, and this is over, we're talking, bear in mind, we're talking decades. This is several years. So he originally created these lots, and yes, they were recorded because that was part of the correct legal procedure for the subdivision. And what he wanted to do was to continue that despite the changes in the ordinance. You know, he wanted to basically freeze his property like from 20 years ago. And that the court said, no, you can't do that. You can't forever lock into the former subdivision. They'll recognize the lots that were created following the laws, and if the law included recording, then that would include it. But what they didn't allow it going forward. In answer to your question, the lots would need to be recorded if that was required as part of the process to create the lot.
Okay, great. Next question. An early slide noted that billboards had special regulations. I'm sorry if you covered them already, but would you mind going over those again?
Well, I didn't really cover them because it's a separate statute. And what it basically says is billboards, even if they're non-conforming structures or non-complying, they're still allowed to be billboards. The non-conforming analysis that we've been talking about doesn't apply to billboards. In other words, well, I'll just be blunt, hands off. There's really little that can be done to terminate a billboard use unless you're willing to pay for it. The legislature has adopted separate sections that apply only to billboards, and so refer to those.
Okay.
Those laws.
Here's a great question. Does abandonment apply to conditional use permits? Well, as a non-conforming use, yes. Abandonment of the use would apply to non-conforming uses. As far as a conditional use permit, that's a separate issue. Conditional uses. It could be, and this is I've seen this in some city ordinances where conditional uses and other approvals expire if nothing's done. Sometimes it's 6 months. For example, on a building permit, and it could also apply to a conditional use permit. If the use is discontinued, let's say for a year is probably a reasonable time, you could include that either in the ordinance or in the permit itself, that if the use is discontinued, then the permit expires basically after a year's time. Okay. Next question, is the city responsible to provide notice to the property owner that a legal non-conforming use exists or has been recently created?
that a non-conforming use is nearing expiration, 1-year abandonment, or that the non-conforming use has expired?
I don't think there's any requirement that that you notify property owners or neighbors of a non-conforming use. Again, in almost every situation, non-conforming becomes an issue when someone complains. And so if the city is proactive about it, then I guess they could, if the city wanted to, I guess they could go out and categorize the uses and decide who gets non-conforming and who doesn't. I don't think there's any obligation to notify people of a non-conforming use. And then as far as nearing the abandonment, again, there's no specific requirement, and it's kind of the same thing. Non-conforming almost always becomes an issue because someone complains. It's very, very much a complaint-driven concept. So no, there's no requirement that you warn the owner that you're about to lose your non-conforming status. I guess there's really no requirement of that.
Okay. Next question: if a residential home is non-conforming, does not meet setbacks, and the lot is non-conforming, is this a non-conforming use? If the house is substantially remodeled, does the entire building need to be brought into compliance?
It would be a non-compliant structure if it doesn't meet setback requirements. And so if the home, in order to qualify for non-compliant status, the home had to have been legal. In other words, it complied with setbacks when it was built. Mm-hmm. So if it no longer complies, then well, first of all, it's allowed to continue. And then it would be within the discretion of the city that if a home would be allowed to be rebuilt in the same place. And in that, you'd probably have to look on a case-by-case basis that if it's possible to build a home, let's say you're tearing the old home down, you want to build a new one. If it's possible that the new home can comply with setbacks, then that should be encouraged probably as much as possible. And again, it's sort of the same thing with the lot. The lot, first of all, had to have been legal to begin with, and now is non-complying because of size or sometimes dimension. Sometimes you have a lot that's plenty big enough, but it's very narrow. So again, the lot has to have been legal at one point and now has become non-conforming because ordinances have changed. Same thing, on a case-by-case basis. If a lot is still large enough to be used for residential use, and if compliance should be the goal. If it's not that big of a deal to move the new home over a few feet so it complies with setbacks, then that's probably okay.
Okay, great. Well, that looks like that wraps up our questions for the day. This has been a great presentation, and thanks, folks, for participating. If you do have additional questions, you can see on the screen there the contact information for the Ombudsman's office, and they're great to get back to you with timely answers to your questions. And please look forward to seeing our next webinar in this series in 3 months. Thanks so much, Elliot, for your time and the presentation that you gave today.
You're welcome.